Welcome to our last official presentation. We're really happy that you've come to join us for our session. Hopefully the donuts and coffee have given you a late afternoon sugar rush that won't wear off too quickly. My name's Margaret Hagan. I am the director of the Legal Design Lab at Stanford. I'm really happy to be talking today about strategic blueprint for eviction and housing law innovation, and to be speaking with my colleagues. We'll do short introductions and then we'll dig in.
Thank you. I'm Aftab Purival. I'm the Hamilton County Clerk of Courts in Ohio. For those of you who are not Ohioans, Hamilton County's largest municipality is Cincinnati, Ohio. Curious, any other Ohioans in the house? There we go. All right. Go Bucks.
Oh, okay. Hi, everyone. Yeah, I know. I'm Olivia Rosenthal. I'm a fellow at Stanford Law School, and I work with Margaret at the Legal Design Lab on the numerous eviction projects we'll be talking about today.
Good afternoon. My name is Rob Wall. I run the Hamilton County Municipal Court Help Center, which is a project of the Clerk of Courts. We assist underrepresented people with civil issues in municipal court, so that's evictions, debt collection cases, other landlord-tenant issues, and small claims matters.
Great. And could I get a read of the room, aside from the Ohio factor? Who here works as a legal aid staff attorney or in legal aid in another kind of function? Terrific. Who here works for the courts or self-help centers at the courts? Universities, government agencies, or LSC, or anyone else who I didn't say? Oh, a technology company, or yes?
None of the above.
None of the above, mystery factor. Technology companies or vendors, or? Libraries, librarians? Oh, terrific. Funders too. Thank you. That helps us get a read on the room. And how many here explicitly work on housing or eviction as some part of your portfolio? Well, terrific. Okay, so hopefully we'll make a presentation that is relevant to all of you and maybe gets you more interested in working on eviction and housing innovations. The question that really motivates our presentation today is, how can we as a community of all different types of stakeholders interested in making the justice system work better, how can we be more strategic and coordinated across the country as there's so much more energy around the eviction crisis, all of the attention that's being paid to it because of lots of reporting in Matthew Desmond's book, Evicted, and an increasing number of accounts about how eviction is really harming people in terms of poverty outcomes and social outcomes, and there's more interest across the country in devoting resources and starting programs around eviction. How can this be a moment that we, especially in the justice sector, can coordinate ourselves to be more effective and impactful in how we spend our resources and develop new projects? And a big call I want to make, I've been making this call for about a year now, partly because of failures we've had at our lab, is how we can move from an approach that's about building one-off websites or one-off apps and hoping that those really make a social impact on people in the justice system. And instead, how we coordinate our efforts across jurisdictions, across different kinds of stakeholders to really help people get from a problem in their lives, an eviction notice on their doors, to a solution where they are in stable housing with their kids in a stable school setting and other social impacts that we really want to see. So we definitely want to encourage wonderful technology innovations, but how do we do that in a really strategic and coordinated way, which is not an easy thing. So some of our goals here is this idea of working according to a blueprint or a network, so that we understand that people, when they have a legal problem, like an impending eviction, that they have this kind of long journey, that we have places to intervene way before the eviction happens, that we can intervene during the eviction, or we can be intervening afterwards. We're also really interested in establishing common best practices. So even if the law and the procedures are different jurisdiction to jurisdiction, that we can still have some common code bases, ways of evaluating things, ideas for interventions that we can work across jurisdictions with. And that also, as there's projects coming out of Arizona or Ohio or Massachusetts that are having really good results, that are a really promising new technology project, service project, or policy project, that we can have really robust ways to replicate those across jurisdictions. So there's a much higher capacity to learn from each other and also replicate good projects. Like, that's the future we want to be a part of. Not everyone building their own app or building their own new website, but really learning from each other and spreading in a more strategic way. So to talk about that in more practical ways, we're going to, first of all, Olivia and I are going to talk about a landscape that our class at Stanford, at our lab, has been doing to try to figure out where are there real hot spots for innovation in this space, in eviction, and what's happening out there in the many different cities and jurisdictions focused on this. Then we'll dive into a specific case study about Hamilton County and Cincinnati and some of the projects that are bubbling up there. Then we'll talk a little bit about a new project that our lab at Stanford is working with the National League of Cities on to get a multi-city cohort to all work on eviction innovation together. And finally, we'll turn it over to you to hear from you and to have you work in small groups to see where you see potential or great ideas around this space in your own communities, and also how you might think about being part of a kind of more cross-country cohort. Any questions before we kick off? All right, thank you so much for paying attention. All right, so let's start off with this landscape about what's happening. We know that there's a lot of talk and a lot of press coverage around eviction, and corresponding to that has been a lot of energy and interest from mayor's offices, local community groups, courts, and legal aid about doing things better. So our lab at Stanford has made this a priority, and we've been teaching classes and devoting a lot of our research work to try to map both what the eviction system looks like from a user's perspective, as well as where there is a lot of activity and opportunity for new interventions to improve it. So on our side, taking our classic human-centered design approach, we've just been doing a lot of interviews. So talking to lots of folks, mainly in the Bay Area and California, about their eviction stories and their whole journey through the system, with an eye to figuring out where there's opportunities to intervene to make the system better. So we've been figuring out what types of people end up getting evicted. We map out their journeys. But all of that's to say is that we've been figuring out how to think about eviction, not just as a single lawsuit or a legal problem, but really a system where there are multiple stages, and each of these stages are an opportunity to possibly intervene and make it better. So before the legal action, there are the phases of just the housing market dynamics, then getting a rental agreement established, and then as problems with the rental emerge. Then there's the actual legal action in the California context, when the unlawful detainer lawsuit is initiated, when the person, the tenant, receives the lawsuit and has to figure out how to respond to it. And then there's the phase of, if you get there, going to court, dealing with procedure, possibly settling or going to trial. And then after the legal action, there's what happens right after that judgment, and then further down the road. So this kind of mapping lets us think more systematically about where we might want to spend resources or find ideas to improve the system. So for each of those phases, we've been doing an inventory about what ideas are already being piloted around the country, as well as new ideas that experts or the users themselves are suggesting to make the system better. So we're just going to walk through what some of those ideas are, phase by phase, as we've already been talking. Maybe Olivia, do you want to join me so I'm not just talking so much? Olivia's been working a lot on this. So maybe let's just take turns to go through the ideas. Yeah. So I'll give you that.
Yep, sure. So sort of the first fundamental one that we focused on was the housing market itself. So thinking about obviously more public housing, more affordable housing, if there are interesting new ways to subsidize housing or to incentivize building of sort of low-income units or adjacent units, especially in California. That has been something we've been looking into in San Jose.
Another area about like very far upstream is about changing how landlords are able to join the market and be able to rent to people. So holding bad landlords to account or preventing them from even offering things on the rental market if there are problems. Lots of ideas about very upstream ways to intervene there. Then in the kind of second phase, when a person is making that agreement with the landlord, there we see some opportunities about finding better matches, making better lease agreements, other ways to start that relationship off in a more protective and strong way for the sake of the tenant. And having more of that kind of prenuptial style planning to make sure that there's more understanding of the lease and more plans inside the lease about what might happen if there are problems with the rental. We don't see a lot of pilots in this area, but this came up a lot in terms of expert or users' ideas for how to make the eviction system better.
Yeah, and just going off that one, some ideas we did hear and that people are considering piloting on the lease phase are whether you could, for instance, pair tenants with representatives, almost a doula-esque kind of advocate to help walk you through the phase, or to have law students be engaged in not giving legal advice, but helping to sort of answer pretty basic questions on the lease front. A third sort of type of idea we've heard a lot are this idea of standardized leases, which is something many people have tried. There are a lot of legal complications, but as something that's come up again and again in interviews, it is this model lease idea.
And then as we start to see problems between the tenant and the landlord emerge, whether it's about making rental payments, habitability, or other issues, here where we see more interventions actually being piloted, including from Stacey Butler in Arizona, and some examples from Australia. But basically, these kind of like, as the problem starts to emerge, how to prevent it from flaring up into a full-blown lawsuit or notice. So this is about helping that kind of early communication of problems, writing letters, gathering documentation, other things to keep that relationship healthy and keep the tenant housed, or tools to help the tenant document and gather evidence at this stage, a la the tools that JustFix in New York provide, how to kind of get a trail of information that could be useful if the problem goes to court.
Do you have a sense of how much of that can be done online versus how much of it needs in-person assistance?
There's some amount of evidence. I mean, there's not good studies in any of the areas. And this is kind of one of our broad concerns, is the lack of strong evidence about where to intervene or what works or doesn't. JustFix is pretty open with its process and what it's learning from giving online DIY tools to tenants or to community advocates in New York City. So they see pretty high usage rates, especially if it's a community advocate or intermediary. But I don't think I can tell you what definitely works or definitely doesn't. We can just see what's being tried out or what's being proposed. Yeah. And then how to get really, like even before the lawsuit is filed, how do we get legal and financial help to tenants as soon as problems start to emerge? So that kind of early intervention to get know your rights materials, trainings, understanding of the eviction system or understanding of your rights. How do we get that to tenants even before a notice arrives about a lawsuit? Or how do we limit who can file for evictions? So, and these come from more law and policy things, like in New York, there's a proposal of a clean hands law so that only landlords can only file for eviction if they don't have any record of abusive behavior or other kind of problematic behavior. Or also limiting when you can file evictions, none in the wintertime, other kind of restrictions on the actual filing or initiation of a lawsuit. Then we get to what we're more familiar with, the legal system, or the official one, when the lawsuit is actually filed. So here we see a lot more experimentation, including from our case study, of how we give that initial initiation of the lawsuit to be more clear and more actionable. So changing how the court communicates to the client, to the litigants, changing what kind of information has to be given to file a lawsuit. And then as people get the lawsuit and figure out how to respond, I think here we see a lot of activity. So this is like the wonderful project from Massachusetts and Quinton, how to respond if you're being sued, how to produce pleadings or things to bring to court with you, or a project that we worked on in Arizona to help you prepare what to say in court, the Rentrevention bot in Chicago. You've been evicted, here are your rights and options. So just kind of digital DIY tools to help people prepare if they don't have a lawyer. Or a lot of human services. So a lot of clinics, right to counsel movement, clearly. How do we get people to a live human lawyer as soon as possible in this legal process to get them options and strategies?
Yep, and just going back to the sort of right to counsel movement, we've also seen examples of sort of when that is not going to be successful in your jurisdiction, are there interesting ways we can either get third-year law students in the court or even having a lawyer from legal aid sit in the courthouse and answer kind of one-off questions but not do full representation. So there definitely is a spectrum for sort of what those right to counsel ideas have looked like. And then sort of one of the last buckets is the actual making it easier to file and answer and participate. And obviously this varies by state and jurisdiction, but in states where you do have to file and answer, we are seeing some work around making that process easier. So in California, for instance, making the fee waiver process easier, making it so is there a minimally viable answer you can file without having to write every possible defense on it. So there is a lot of interesting work and research that still needs to be done there, but we think there's a lot of activity that will keep going.
Then when you show up to court? Yeah. So then there's the whole so you made it to court, you didn't default. How do we help make that the most respectful and least biased process as possible? So lots of talk about mediators, representatives, balancing the power dynamics, a lot of in-court kind of interventions, or putting more social services into the court. So akin to a collaborative court or other kinds of like multi-service options inside the court. How can we have more collaborative housing courts? There's also a really big trend around eviction diversion programs, which we'll talk about later, about kind of co-locating services or getting people onboarded onto social services or with emergency rental assistance. How do we improve negotiations and settlement? And then after you actually have a judgment, whether it's a default found in your favor or not, how do we help people even make sense of that, figure out what their options to mask their record are or what their next steps are, getting them into stable, affordable housing if they are evicted, and then further down the road, helping them deal with eviction marks on their record, and just understanding the system and gathering better data to even know what just happened and how to improve the system. So from that exhausting walkthrough, there are lots of different ideas about how to make this gigantic system better. And there's very little evidence about what works and what doesn't. And there's not much structured data that we have from courts about what actually happens to people, whether the eviction, whether they've defaulted, whether they've been officially evicted, whether there's been a settlement or otherwise. We don't have a lot of data shared about that. So.
Yeah, and a lot of these initiatives as well are post-2016, so most of them are under 4 years old. So even the ones that do have some data, it's not very robust and it's anecdotal. So that is definitely one sort of challenge when one city sees another city doing something and wants to do it. The first question they'll ask is it working? And that's a question that is harder to answer in this field than in others. But as Margaret mentioned, we are seeing local coalitions forming around a few of these ideas that she spoke about before, one of which is this idea of an eviction diversion program. I'm sure some of you here are from jurisdictions that may have an eviction diversion program.
Does anyone have an eviction
Does anyone have one?
program?
Where are you all from?
We're with Georgia Legal Services, but we're very different than the other eviction diversion programs. But yeah, I think we're closer to North Carolina's.
Okay, Durham's.
Well, yeah, our model's similar because it's a giant statewide dealing with a lot of rural areas.
Okay. Yeah, so we are, any other diversion programs?
Virginia's doing a pilot project in Richmond this year, spreading it to 5 more states next year.
Yeah, I was actually going to use Richmond as an example, so that's helpful. Oh, okay, awesome. Yeah, so these diversion programs can,
Just a question I heard over there that was in my mind is what is
that
the
is
definition?
of an eviction diversion. Yes, so that is what we are going to explain, yes. So they can look really different. For most of these, an eviction diversion program starts after the UD has been filed, so it's not eviction prevention in that it's after someone has already gotten court paperwork, but they can look different. A lot of them, for instance, Richmond's eviction diversion program basically is a combination of things. They've received funding to put a legal aid attorney in the courthouse to answer questions before the court, and the government gets involved in helping landlords and tenants come up with an agreement so that they don't even have to go to court. So In Richmond's eviction diversion program, for instance, landlords and tenants have to voluntarily suggest to the court, we want to enter a diversion program. If you meet certain criteria, you are then eligible for city money to pay up to 50% of the rent you owe. So in a diversion program, basically a baseline definition is trying to avoid the eviction from happening by offering some form of money and helping a landlord and tenant come to agreement outside the court. But it can look different depending on the jurisdiction you're in. We've also seen a lot of eviction prevention and emergency fund programs. Those are funds that are typically before the lawsuit is even initiated. So for instance, emergency rental assistance funding for tenants who meet some eligibility criteria. Oftentimes those eligibility criteria can be things like you cannot have been evicted in the past year, you have to meet certain income, you have to show that you'll be able to pay your rent the next month moving forward or something like that. As Margaret mentioned, there's obviously a hub around right to counsel in housing courts, and then, which we'll be talking about more with our case study, is this movement towards tech self-help for either creating legal documents, for creating answers, for answering questions, and for even presenting evidence. The sort of last bucket of things we're going to touch on are these redesigned court notices and summons, which again, our case study will speak to.
Does anyone have right to counsel active in their jurisdiction, like a right to counsel coalition or actual laws on the books? Can you just say which jurisdictions you're from that has right to counsel activity?
Legally.
Troy?
DC, sort of.
Any more right to counsel activity? So it's definitely city-based except for Massachusetts. That's very interesting. Okay, that's great. We're almost to much more specific. We're going big to small. So our team at the lab have been trying out different interventions. We have a project going in Arizona where we are sending people mailers after they've been evicted to see if we can get them to avoid default to show up to court. And we have a website there to help them prepare magic scripts and documents if they do come to court. We're finding mixed results with it. We are going to be publishing more as we get enough statistical power to talk about whether it works or not. But we're definitely moving towards this idea of interventions that are not just at one of those stages, but that we're coordinating across, that we have multiple new designs of paper, technology, policies, and services. We're trying to do something that can intervene at multiple stages and hopefully get people to participate in the eviction process and defend their rights. One of those projects is with Hamilton County, so I'm going to turn it over and hear more from a specific jurisdiction.
Wonderful. Thank you so much. It's really a treat to be here with all of you and presenting with my colleagues. As I mentioned, my name is Aftab Pureval, and I'm here with my colleague in Cincinnati, Rob Wall. And a little bit of background before we jump into our specific issues, because I think that will really inform our discussion and kind of answer the question why the Help Center, and then why these specific interventions that we're testing out in Hamilton County. My story, I'm a lawyer like so many of you. After law school, I worked at a large firm as an antitrust litigator. Then I was a federal prosecutor. I was in-house counsel for a while, and then I ran for office, and I ran for the Hamilton County Clerk of Courts. Yes, that is an elected position in Ohio. And so, you know, the question is, why on earth would you run for the Hamilton County Clerk of Courts when there's so many other things to run for? Certainly that was my mother's question. And you know, before you look down your nose on the Hamilton County Clerk of Courts, I'll have you know our 9th president, William Henry Harrison, before he could be inaugurated, had to step down as the Hamilton County Clerk of Courts. Of course, 31 days later he died. But yeah, that's a launching pad. But I really did. I ran for this office specifically, intentionally, because criminal justice reform gets so much attention, and rightly so. We focus so much on the police, on prosecutors, on judges, and yet we are ignoring a massive population of folks and a massive issue on the civil side. And this idea of access to justice and reforming our justice system on the civil side really energized me because as a litigator for so many years, I saw just how inequitable our courts could be. And so when you think about the clerk of courts, I view that as the front door to the courthouse. And when the front door is inaccessible, inefficient, and antiquated, it really does undermine the rest of our court system. And in Ohio, we are lucky enough to have a Supreme Court, and specifically a Chief Justice of our Supreme Court, who sees eye to eye with that philosophy. There was a task force recently created at our Supreme Court, and one of its findings is on the board. Individuals unable to secure legal representation in civil matters are left with no choice but to navigate an unfamiliar, complex court system alone. And so I ran for this position and I won. And by winning, I became the first Democrat in 100 years to be elected to that position. I don't say that as a partisan comment, but only to identify the fact that I'm a brown dude named Aftab, and I won a countywide race in Ohio, so thank you. But I'm in office now, and now what, right? Now I have this opportunity to create real change, to even the playing field. So one of the things to start this process of thinking critically about where the need was in Hamilton County was to really kind of take stock of the access to justice ecosystem in our community. And so, like so many of your jurisdictions in Hamilton County, we have a wonderful, wonderful legal aid program. We have volunteer lawyers for the poor. We have clinics where the kind of status quo model of one client to one attorney takes place. We have through something called the OJPC, Ohio Justice and Policy Center, and through our public defender's office, we have wonderful same-day expungement and record sealing programs. So we do have quite a thriving ecosystem. But yet, and still, and probably similar in your jurisdictions, there's a massive population of folks who either do not qualify for legal aid assistance or our various programs don't have the bandwidth to help them. And so they're utterly on their own. So thinking kind of critically about how do we meet those folks where they are and meet their needs, the first thing that we did was put together a posse. So we engaged with the University of Cincinnati College of Law and inspired them to tackle this issue with us. We got municipal court judges to buy into this program, retired attorneys, and we came together and we kind of thought, again, with, as Margaret mentioned, not a whole lot of data and not a whole lot of line of sight of what was working and what wasn't. We came up with an idea of a limited legal advice help clinic. Because there is this professional rule of ethics in Ohio that allows for this niche space of not full representation, but limited legal representation. And so we launched the Help Center with the help of so many of our partners. And the logistics of this are, it launched in September of 2017. The budget the money comes specifically from my office's budget, the clerk of courts. It's about $100,000 a year to hire one full-time attorney and one paralegal and a bunch of volunteer law students and college students and attorneys for anyone facing civil issues in municipal court to come without an appointment and either get wayfinding, kind of more court navigation help, or to get limited legal advice specifically about civil issues in municipal court. And in Ohio, that includes evictions, landlord-tenant issues, debt collection, and small claims. I've dropped my notes, so 1 second. And so when you look at the data from the first year, we can see that a vast majority of our clients and customers are looking for just information, right? Total visits 13,000, daily average 59. The legal advice portion of our clinic is only 894, but the information is 12,000. So that that's I think an important data point as we look to the future of the Help Center and how we prioritize our resources. If you look at the demographics of the people who are coming to the Help Center, you see that it's quite broad and diverse. One of the intentional decisions that we made when creating the Help Center was because we didn't quite understand where the population was or what the demographic was, we tried to go as broad as possible and impartial as possible. So there is no income cutoff for the Hamilton County Help Center. We help everyone so long as you're unrepresented. And we help both plaintiffs and defendants. We help both landlords and tenants. And what you see from the data is that, by and large, the folks that we are helping are living in poverty, they are diverse, and they are women. And when we look at, again, the first year, we were incredibly successful. The National Association of State Courts gave us a national award. The Chief Justice of the Ohio Supreme Court did a press conference at the Help Center and called our Help Center the model for the state of Ohio. So we're incredibly proud of that. But when we look at the data, when we compare the amount of cases in municipal court and the kinds of cases that are happening in municipal court compared with the kinds of clients that we're serving and the issues that they're facing, it was clear to us that there was a disconnect. Our help wasn't necessarily helping where it was needed most. Evictions and creditor-debtor were dominating the dockets in municipal court, and those issues weren't necessarily the issues that most of our customers coming into the Help Center were facing. So the question is, why that disconnect? What's happening in Hamilton County around evictions that is leading to that missed connection? And just some context, some stats. There was recently a study of evictions in Cincinnati, and it found that about 50% of Cincinnatians rent. So there's a massive population out there in our city who are susceptible to evictions. Eviction filing in Cincinnati is a little higher than the national average. Less than 1% of eviction filings are actually ruled in favor of the tenant, less than 1%. And a massive population of those cases result in a default judgment for the landlord. So in other words, people just aren't showing up to court for whatever reason. And similar to the demographics of the clients that we were helping, the report showed that the community of folks predominantly affected by eviction were Black women living in poverty. Some other kind of structural problems or challenges that Hamilton County faces are, somewhat frustratingly simple to solve. First and foremost, there's only 2 entrances to get into court. So there's a long security line because all of the dockets start at the same time. So people are being evicted in absentia, which is, a frustratingly easy issue to solve, and we just haven't had the buy-in to solve it as of yet. The eviction docket, goes very, very quickly. On average, I think parties have about a minute or 2 minutes to make their case, and then a decision is given. So a lot of folks who we are helping in the Help Center just want to tell their story, in the way that the court is set up, they're not able to do that. So our strategic focus in 2018 and from 2018 to 2020 is really focused on 2 issues: eviction and creditor-debtor issues. And I'll let Rob talk about our partnership with Stanford and how we hope to affect some change in that area.
So I wanted to mention a couple things about, we did this review of our case outcomes, after the first year of operation, and we realized we had these 2 underserved areas, evictions and debt. We also had, years worth of experience of seeing, 60 or more people a day at our Help Center, and we served many, many people who were dealing with evictions and debt issues. We serve people at all stages in the process. And so we'll help somebody dealing with an eviction when they're having problems with their landlord or behind on rent when they receive a 3-day notice after an eviction's been filed. After, as Aftab said, missed their court hearing or 10 minutes late for court, and they're trying to figure out what they can do about it. People who are living with eviction records, on the public record and trying to find a place to rent. We help people in all stages, and similarly, in debt collection cases, we're assisting in all phases of those cases. So we're seeing people who are being garnished and trying to deal with these situations at late stages when their legal options are lesser. And we made a really intentional choice that we wanted to do work to get people earlier in the process when we could do more to help them and when their legal options are greater. And what we would see, is when that doesn't happen, people would show up to eviction hearings, sometimes quite prepared, but not understanding the full court process. So in Ohio, like a lot of places, evictions are kind of a 2-stage process where there's a first hearing related to possession of the property and a second one related to who owes who what money. And so people would come to the first hearing with a well-documented stack of photographs, stuff from the health department about the leaky roof in the place. And they were under the impression that they were going to have a hearing where a magistrate was going to look at their whole situation and they were going to make a measured kind of equity judgment about what should happen. And they walk out literally less than a minute later having been evicted. As Aftab said, we see people who are a minute late for 10 minutes late for court. We see people who just freeze up, who may have had a legal defense and knew it, and get into a venue that is not, 98% of these cases have an underrepresented tenant, but is built for a system built for attorneys. When we do see people early, what happens is a lot different. We are able to screen for defenses, and when there are defenses, we're able to help people work up that defense and talk about how to present that in court. And oftentimes that ends with a script where somebody will have, here is the thing you need to read in court to, in this minute-long hearing, make the magistrates have sort of a laser focus on your defense because you really have a very short period of time to figure that out. For people that don't have defenses, we really saw that when somebody knows that they don't have a defense early in the process, that is a lot different situation knowing when you have 3 weeks or a month's notice that you don't have a defense and you either need to settle with your landlord or move than when you're leaving eviction court and you have 7 or 3 days to move. It's a completely different situation. And when we see people who don't have a defense, we can help them, give them advice on settling with their landlord. We have a student master's in social work that is often at our help center that can sit down with somebody and connect them to community resources, but also help them make a plan for moving more generally. So there's a lot that we can do, but as we saw in our numbers, we're just simply not reaching people at that time. So, so that's what made us, focus on these two things: targeted outreach, and creating more resources for people who are coming through eviction court and coming to our help center. So if we reach people, what do we have in place for them when they get to us? We decided to focus on the summons. One, because being in the clerk's office, it's a place where we're particularly well situated to be able to change that document, number one. But more importantly, to do targeted outreach in a court process that lasts, the summary proceeding that lasts, from the day of filing to the court date, is, at the longest is about 4 weeks, but usually shorter than that. It's very difficult to do targeted outreach to that population at a time where they need to get this information. Our solution was to focus on the summons, which is, when someone gets that envelope from a bailiff or has it posted on their door, and they open that official envelope from the court, it is the first document they see. So it is this opportunity to at least what we're hoping is that if done right can give people really actionable information that can change their situation and give them things things they can do to get help. And then resources for people who are underrepresented. I'll talk about the website that we're working on in a little bit, but also expanding and building out more of our informational materials and hiring a new staff attorney. So we just recently onboarded a second staff attorney to meet this great need for limited legal advice. So the 98% of tenants who are underrepresented, they're not just underrepresented, they often get no legal assistance whatsoever. So that's just a critical need.
One thing to add, we're also looking at building out a mediation program. We haven't quite figured out when the right time for intervention is for mediation. The three potential ideas we have right now are, number one, the largest evictor in Hamilton County is actually the Housing Authority for Public Housing, which is obviously a government agency. And so we're hoping to partner with them to do pre-filing eviction mediation to maybe reduce the number of those filings. The second is mediation for our help center clients who are kind of in the process of the eviction proceedings. And then the third would be same day eviction mediation between the landlord and the tenant on the day of the eviction trial.
Thanks. So in starting with sort of our process of work on the summons, what you have up on the screen is our starting point. What the current summons was. It's probably hard to read, but you can take my word for it's bad. Some of the sessions have been in today. I've talked about thinking through who this is designed for and what's actionable about the document. So what does it lead you to? I would be hard pressed to know who this is designed for. It's a document written clearly by attorneys in legalese. It appears to have the goal of meeting the minimum standards as required by the civil rule for what a summons is required to have on it. I don't know anyone who this would be sort of targeted for, nor does it do a particularly good job of giving you an actionable next step, which really, even looking at the face of Ohio's civil rule, really kind of pushes in that direction of requiring that at a minimum it talk about the consequences of inaction, of not doing something, which the positive flip side of that is that it would give you an actionable next step. So it's, this is the first document somebody sees, can be quite intimidating. And obviously has not had to design on it or connect to any sort of community resources. So starting from there.
Rob, there's a question over there.
Oh, yeah.
Can you talk a little bit, maybe later is better, but can you talk a little bit about some of the discussions you've had with the judges, the victors, about what is slowing down a process that Desmond points out works very well for them? Can you talk about what some of those discussions have been like?
Yeah. Do you mind if we discuss that later? Yeah, I appreciate that.
Mm-hmm. Yeah, it's a very good question. So we embarked on this process, and one of the things we found out, first just locally, there was a community of, especially of advocates, both legal advocates and community and tenant advocates that were really ready for change and really enthusiastically wanted to be involved in this process, which redesigning a summons isn't necessarily the most compelling or interesting thing to get people involved in, but we had a huge amount of enthusiasm for the project overall, but also just getting people in for our focus groups to get feedback. So we did two sets of focus groups, one remote and one in person, and in both sets of focus groups, we had one sort of legal expert group that had a eye towards, both an understanding, a deep understanding of the legal process, but also an eye towards like the legal requirements that a document like this would need. And then we had a tenant and community advocate focus groups in each of these 2 sessions that looked at, was this communicating what it should? And as part of that process, we really looked at kind of every aspect of this document. Just kind of 2 examples. So the bottom right corner, there's a picture of the courthouse. That originally was a map, and just locally, community members thought that map really wasn't going to be that useful, and partially it's just the particular where the courthouse is situated. So in Hamilton County, there's this big courthouse, and there's also behind it the Justice Center, which is the jail, but also houses some courtrooms. And there's a federal courthouse just a few blocks away. And so a map that is kind of abstract in appearance, the community advocates thought everyone knows what that building is. If you just let them, that's what they need to know. Just, oh yeah, it's the courthouse, and they'll understand where to go. Another example is, in terms of sort of the wordsmithing, we were trying out a variety of, I learned the term behavioral nudges, of sort of, what are, what would motivate someone to engage in this process. And, we had different versions of that. One, I kind of remember in particular was this idea that, go to court to tell your story, sort of like a positive motivation. And we got really strong feedback from the, I think both the experts and sort of the community advocates that was just the wrong message, because in a 1-minute eviction hearing, you can't tell your story. That's the wrong kind of perspective to go into sort of this hostile venue. And though that process, I think, overall needs to change, the document as it stands to prepare for that process really shouldn't give sort of a false idea that you're going to have an ear that's going to listen to your story in that way. So, what we ended up with in New Summons is, 1, it's in plain language. 2, it's structured around the actual court process, which was something that we work at our help center to clarify with people. And using this first document as a start to do that. So it talks really specifically that there's a first hearing about possession, and that's what will be considered there. There's a second hearing about money, and it's just kind of visually separated and treated as 2 separate things, which the first summons didn't do very well. It makes consequences very clear and kind of puts the consequences in sort of positive terms. So it's both sort of negative. If this happens, if you don't do this, this will happen, but also positive. Don't ignore this or show up to court, things like that. Importantly, it links to community resources. So that gray box is a whole Get Help section. So there's information about the help center, about legal aid, about getting rental assistance and disability accommodations at the courthouse. And at the very bottom, there's a text message feature where someone can actually text this number. They'll get information about the court. They'll get some of the same information about getting help. There's an electronic scheduling link, so somebody can very easily on their phone click on this link and schedule an appointment with one of our attorneys at the help center. And so we're trying to kind of, both give the information but remove barriers to accessing that help through the summons. The eviction website is something that we are less far along on, so we're kind of earlier in the design process. It is based around a website in Arizona, which I actually realized I neglected to sort of talk about just how we, how Hamilton County and Stanford sort of came together working on this. So the Self-Represented Litigation Network had a listserv posting about this website in Arizona, and we had kind of gone through this process of looking at our outcomes and really thinking about what we want to do. And it was in the vein of what we were thinking about, and we cold called Stanford and asked them basically, how'd you guys do this? And then had a larger conversation, which led us to all this other work. So the website is based, roughly around the Arizona website, but it has some big changes, I think, that respond to sort of the local context. We also did some preliminary focus groups. We're going to be doing more focus groups and user testing moving forward this year. And it's structured, one of the things that we did come out of the focus groups with was this structure of 3 options that when you're dealing with an eviction, one of the goals of the website, I guess I should say, is that what the general options are and know how to get help. So the 3 options are, move, settle, and get help. So we have fight the case in court. So we have structured around that. And we also have sections for landlords and tenants because the Help Center assists both. So in 2020, we're planning, the summons will be launching very soon, and I think February 3rd is our date for launch of the summons, so we're excited about that. We're going to be doing a study. So the first study is the old summons will be sent to a random group, and the new summons will be sent to another random group. And we're looking at 2 things. Assessing, are people getting legal help early, which is critically important, and secondly, are they showing up to court? We're going to be tracking. Legal Aid is partnering with us on are people getting help early, so they're going to be doing some of this tracking. At the Help Center, we're doing surveys that ask some further questions to sort of build a profile, sort of what motivates people to come get help, so we can get some more information about. Are there gaps and are there things that we can leverage to get more people through the door? And we're also going to be doing a follow-up text message survey, with the hope of really gathering some good data on how an eviction affects somebody and the true outcome. Did the person move? At what stage did they move? Did they stay? Was that staying because they worked out the landlord or not? Is their housing situation better? All those kind of questions are basically impossible to gauge from the court record. In the spring of 2020, we're going to be launching the website and doing a second study, one that has a link to the website and another that doesn't, to kind of gauge the effectiveness of, one, are people using the website, and then what the effectiveness of that website will be. I believe that.
Yeah.
So maybe it's a good time to answer that question, and please ask other questions. But as the clerk and officer of the court, it's important for me to understand the efficiencies of the court and how well it's working on behalf of all folks, and how well it's working for the court and for the judges. And so I'll say, when we launched the Help Center, not everyone was supportive of it. Some in the local bar weren't necessarily supportive. Some of the judges weren't necessarily supportive. And our main message to specifically those folks and folks at large was that we really believed that the Help Center would make dockets more efficient and generally create a more even playing field for everyone. And that seems to have been a persuasive argument among that community, because judges are quite interested in the most efficient docket possible, and when you have litigants who are more prepared for court can proceed in a more predictable and efficient way. And then the other thing is when you look at just a vast majority of folks getting evicted via default judgment, there's clearly a breakdown in how the clerk's office is communicating with those folks and notifying them of their court date and court location versus them actually showing up. So I think there's just a public policy need to clean up that summons.
Yeah, I'll take a few more questions. Maybe here, and then here. Go for it.
This is kind of in line with how this panel started. So we're talking about making sure that our partners are talking to each other and not just one thing there or there. So when you're talking about summons, I happen to know at least one other program, legal aid program, South Carolina Legal Services, did this too, change what people perceive, and took the time to redesign it, got a lot of support from the community as well. So when you were doing that, I know you spoke to community stakeholders and you spoke to a legal expert, but did you speak to the other, so I'm curious who you spoke to, or if you spoke to other legal aid organizations that had done the same thing as well?
Yeah, we primarily exclusively spoke to folks in our community. So that's a good learning for us and probably for everyone here to continue to think more globally about the experiences out there. I will say that, it's been a struggle for Rob and I to find outside resources, to find folks who are interested in this field, which is why I'm so happy to be here. And that's frankly how we stumbled on Stanford. It was dumb luck. We just cold called them, and so that's a good learning for us as we move forward to really broaden our outreach outside of just Cincinnati and specifically Ohio.
Yeah, and I actually think this is a great segue to our multi-city innovation cohort, because that very,
This
very
is
short.
And then we'll get to
Yes.
questions.
So basically, we have heard that feedback a lot, again and again. So we are now working with the National League of Cities to pick the inaugural cohort of cities who have demonstrated an eagerness to work on effective and innovative eviction responses. So the first cohort will be around representatives from 12 cities with the goal of having numerous classes after that. And these cities will come together, share their learning, share the tools they used for in a summons rewriting. This is our template, this is what it looked like, this is who we spoke to, and really detailed sort of granular paths forward with the hope of more sharing between cities and between organizations, because we think it's not only important to make sort of these types of innovations more scalable, but also to get better data on what's actually working and what's not.
Because I think, just to say a few comments before we open it up, I think we have a lot of experience as our position as like a lab of people coming to us saying, hey, we're in this city and we have an opening, like we have some interest in summons redesign. And we as a lab can spend some amount of time doing research, putting out messages on listservs like SRLN or other wonderful ones focused on access to justice, or doing what we can to find stuff that's online. But a lot of stuff is not very well documented online. It's all this local knowledge. And we have so many people who want to do something and spend money in this area in particular. So as Olivia was saying, we kind of got inspired by the basic income movement that the National League of Cities was involved to get more structured experiments and policy making around the whole interest in basic income and how hot that is, where they got a bunch of cities who had some amount of interest and leadership buy-in to that and community involvement, and then structured a nationwide group of experiments with standard evaluations, data gathering, planning. Could we do this for something more in the legal system? So National League of Cities, if you don't know, are a nonprofit civic organization that bring together mayors' offices and other city executive leadership for regular meetings, best practices sharing, much like our conference, but in a parallel vein of city leadership. So we're going to be recruiting this handful of cities and leaders starting in March, trying to gather as much anecdotal evidence as well as well-documented and more controlled evidence about what works or doesn't, and all of that giant list of ideas, and then working through how to get pilots off the ground with the idea of replication built in from the beginning. So the whole goal here is that if we work as a cohort instead of as one-offs, we can expand on single pilots. So as we're doing summons redesign in Hamilton County, we can be planning on how to scale that to other cities in Ohio and beyond. That we strengthen how we innovate in the legal system by getting more non-legal people involved and spending their money on things that can really reform the justice system, because we know that mayors' offices have deep pockets. And as we see with Right to Counsel, they can fund a lot of legal services innovations that if we stick with just other lawyers, we can't fund. And also that we can learn more about what works and that we're spending money more wisely. This is the real goal, is that we're spending things, whether it's upstream in the middle of the legal problem or downstream, that really get people out of poverty and to a better standard of living. So if you want to think about practicalities, or if you want one of your cities to be part of this cohort, you can come talk to us. We're just launching the application with NLC in the next month or two. And we'll also be building online resources where we profile in hopefully very practical ways, all of these eviction diversion programs and clinics and other practical services, tech, and policies that are happening around the country, how much they cost, how they got it covered, how they set it up, code bases, as much as we can share to get it as easy to replicate as possible. So we'll be investing in that as well. Now we wanted to turn it over to you, so maybe let's do some questions, and then if we have time, we can work in small groups, but there were so many questions, so let's get those. Let's start over here and then move over, please. We do not have a controlled, if you want to be some other kind of jurisdiction, yeah.
Sorry, a lot of regulations target or metropolitan areas, and when you're dealing with Florida.
Let's talk about that. Yeah, let's talk.
So, just like someone will ask, as a court person, I have to operate under the burden of creating just as much on the other side as well. So one thing we see a lot is the Chevron pop networks. And people with news, people react to the house crisis line. What is it with landowners really look at that? In cases where we see a lot of small landowners showing some curious how you did that. If that feels like part of an hour, things came up, or how you're managing the career
Yeah, so we have been committed from the beginning. Yeah, sure. So if I could try and paraphrase your question and please give me feedback. So gentleman is a court personnel, and when he's thinking about access to justice, he thinks about it not just from the tenant's perspective, but also from the landlord's perspective, particularly the mom and pops who are dealing with their own housing issues and their own issues as it relates to the economy. And so what has been our experience in that arena, and any thoughts on that? And yeah, so right from the beginning, I've been very clear about my approach, which is to help access to justice everywhere, which is why our help center is designed to help everyone, both landlord, tenant, both creditor and debtor. And if you look at our data, after our first year, 16% of the folks who were coming in were landlords, and 18% were tenants. So while we're helping more tenants, there are landlords coming into the office who we're helping. And when we think about the eviction website that we're working on, there'll both be a tenant and a landlord function for that. And then when we think about the summons, I again just think it's good public policy to ensure that not 90% of eviction filings are ending in default judgment because the parties aren't showing up. So everything the way that I look at the issue, the lens that I'm looking at it, really is about as objectively and as efficiently as I can run the court.
Can I add one thing to that?
Yeah.
So looking at our help center data and the municipal court data more generally. So in eviction cases, in 2017 or 2018, there were about 13,000 evictions filed. And 10% of landlords are underrepresented and 98% of tenants are underrepresented. We see about roughly equal numbers of landlords and tenants coming into the help center. We assist in some way, so it could be with most of the time with information, practically all of the unrepresented landlords through our help center. So I think we do a great job of assisting the mom and pop landlords. What we identified was a huge gap and a huge missing piece of the 98% of tenants who are underrepresented. We weren't able to get through the door in the same way, and that's really why there is this kind of specific focus. But as Aftab said, one, the help center is open generally with materials for both landlords and tenants. The eviction website will also have information for landlords and tenants. I think at times we have to remember to talk about that, especially as courts who are neutral. But I think as the services are structured, the gap is not with landlords; it's with tenants.
I would just add really briefly that a lot of the services we see, the diversion programs, the mediation programs, a lot of that is about mutually beneficial outcomes. So I think a lot of the more in-person services, less the tech, is about really finding something that works for both and getting money into their pockets, dealing with mental health issues, other kinds of things that clearly the landlord has outcomes that we care about too. Yeah. Okay, moving on down. So we're trying to map the policies and legislations. This is a huge process. I'm sure most of you know this is county by county, state by state. So our lab at Stanford is working with the eviction lab at Princeton to try to, at least in the US, map out what are the court rules and the actual laws around eviction, how much time do you have, and the other kind of laws that affect the tenant and landlord relationship. So even just getting a handle on what the laws are. But we can see a lot of energy starting in New York and other places to really change what the rules of the system are. So I think as we map that, that's definitely on the agenda in a lot of jurisdictions. Obviously, right to counsel is one legislative movement to get legal assistance to at least some of the population facing eviction, but then broader reform is also very hot right now. Whether it can pass in states other than New York is of interest. Yep.
For AFTAB and Robert, if a lot of your tenants are getting stuck at the courthouse door and getting defaulted as a result, is that because they're trying to carry cell phones into the courthouse and they're prohibited, or some other reason?
It's simply because all of the dockets start at the same time. And so folks think, okay, my hearing starts at 9, I'll get there at 9. If you get there at 9, then you're going to be waiting in line for, 15, 20 minutes. And if you're late, then you are in absentia evicted, or, you're facing really dire consequences because you can't get through the line. I'm not passing the blame, but I don't control the security in the courthouse, and I don't control when the court's dockets are held. But it's one of those issues that is frustratingly straightforward, but there's enough stakeholders involved that you have to get everyone on the same page to change the status quo, and as many of you know, that's very difficult.
Security lines in Virginia are often caused by cell phones.
Yeah, so the security line is caused by cell phones, it's caused by keys, all sorts of metal objects that someone has to remove. So.
I'm wondering if there's any data on default or appearance rates for electronic notification of tenant versus paper only.
No, I don't think so, unless anyone has something counter. Electronic notification would mean that you were served in some way over email or some other kind of from the court.
Pre-filing or for court hearing notifications designs.
I haven't seen any of that. I would be very interested. I think as there are more tenant protection ordinances, there are more government agencies that are collecting when a notice has been filed pre-lawsuit, like in San Jose. Now when a landlord gives a 3-day notice, they have to also tell the mayor's office that they are filing that notice. What if the mayor's office asked for the cell phone number and sent a text message to the tenant with links? That hasn't happened yet, but I think that's one of these kind of upstream things we're interested in. My hypothesis is that it would be maybe more likely to at least get people to ask for help, if not actually fight back or respond strategically. Yes, please.
Is it possible to share the slides in the Dropbox? I didn't see it there.
Oh, yeah, definitely. We can do that. What we aspired to do was to hear more from you about anything that's bubbling up in your jurisdiction. We're really interested to hear, especially since we have you all in the room. Does anyone else want to use the last few minutes to just say something interesting that's happening or being proposed or talked about that you think might be something that other people should know about?
So I'm from Georgia, and if you want to hear things that scare you, ask me about our tenant laws. I think some of the things that are most problematic. Thank you. Some of the things, and I'm from Atlanta, so I'm like the areas are generally like a bit more liberal than other areas of Georgia. I think some of the things that are most problematic for our staff attorneys when they go into these courts and they see what happens are like the sort of invisible ways that aren't easy to track, like the sort of qualitative ways that judges like ignore the law. So it doesn't really matter what the law says. And tenants are unable to file appeals because they don't understand how to do that, and we don't have data on that. The good thing is that we are being able to, even in some counties, still Atlantic counties, but that are a bit more rural and traditional, we've had some success, like finding one person in the court who really wants to take this under their wing, sort of like you did in that area, who wants to really develop that, teaming up with them and finding ways to make it happen, even if it means we've got a space in the courthouse where we're not allowed to have a sign, but the clerks know we're there, so they tell people. And then they have to knock on the door because it has to stay locked. But we're there. You know, like those sorts of smaller movements and trying to develop that into bigger things. We also, this was exciting, we got the anti-retaliatory law.
Oh, wait.
Yeah.
Okay, so last year, we got our very first anti-retaliation law so that when a tenant went to code enforcement, the landlord can't just evict them. So now that's illegal.
Yeah.
And that is the only tenant protection that we have.
We're still excited about it. We're still excited about it.
Let me take it all the way across. Yes. Oh, you had a question too, Susan, or no?
Sorry.
Oh, okay. I'll come across. And do you want to introduce yourself too, so we know where you're from?
So being from Florida, I'm always excited when somebody says, no place has it worse. So in Florida, and you talked a little bit about the use of one of these types of tools, it's very common for a tenant with a conditions case to stop paying their rent so that they can force the issue on the conditions. Unfortunately, that just leads to an eviction, because in Florida you have to give a notice first, give the landlord 7 days, then you can stop paying your rent if the landlord doesn't fix the issue in 7 days. So with some help from funders locally and from the Bar Foundation, we started a very small project in Jacksonville to advise folks to come in, and we would help them prepare the notices using the help of a volunteer lawyer and staff. And in a year of doing this, very low key, we have not had a single person become evicted after giving the notice correctly. So, but I also wanted to say thank you to the clerk's office in Cincinnati for leading the way from the political standpoint, because that's very strong.
All right, one last opportunity. Anyone want to brag about something that's going on? Tell us something good? All right, all the way back across. I can do this.
Cleveland brag? Cleveland's like crushing it. We don't like to brag.
Come on. When good things happen in Cleveland, you got to talk about it.
Was it you?
No, let my colleagues.
Well, so first off, I would commend Cincinnati. I mean, we were sitting here. We're about to implement this right to counsel in July, and we just went through an election. So we have a housing court, which has been a model court, and we have a long history of having a great relationship with that court. There are many ex-legal aid attorneys who serve as magistrates there. But the election, the judge got defeated in a surprise. So we have a brand new judge, a housing judge in Cleveland, as we're about to implement this right. And, as we know, it changes many things. And the new judge just came in and laid off a few of the magistrates, one who had been there 25 years, the chief, who was an ex-legal aid attorney. So, we had a lot of work to do. Now we have more work. So we will definitely be reaching out. We have started the conversations with the clerk's office around the summons. And, it took a long time to get to where we are. And the right is narrow. We would like it to be broader. But all of these things, we should applaud the steps the achievements and keep working, because this is so important to turn the tide.
Can I ask a quick question about your right to counsel? How did you fund it?
Well, that's a good question. So the city's in for part of it. The county hasn't committed yet, but the lead funder is United Way, and United Way and Legal Aid are raising money. So, it's the city has committed a portion of the funding, but the budget's going to be probably around 2.5 annually, and what the city's contributing is a fraction of that. Most of the savings are at the county level in terms of the real benefits, so they're still deciding what the number is.
I know we are at time. Thank you so much for paying attention. I know we covered a lot of stuff. We're really excited. If you have other ideas that you've been thinking about or you've seen talked, we're trying to map as much as we can. Thank you so much for your attention. We're here to talk if you want to talk more. Have a nice evening.
Nice job.